Good afternoon, Judge Kgoele.
Good afternoon, Justice Maya,
Are you well?
Deputy Chief Justice. Yes, thank you.
All right. Are you comfortable?
No, I'm trying to cope. There are a lot of goosebumps in my...
No, settle down. You are in a safe circle. Don't worry about anything.
Thank you so much.
Okay, we will start your questioning now. You hold 3 law degrees, legal degrees.
Yes.
Which are
Deputy
they and
Chief
where
Justice.
and when did you get them?
The first one, I got it from the University of the North.
Is that the BPROC?
The BPROC, yes, the old BPROC. And the second one was an LLB, because in the olden days, BPROC was not mixed together with LLB. Now, the third one is LLM. Both the LLB and the LLM, I got it from UNISA. I did it through correspondence whilst I was working.
What was your area of specialty in your LLM?
I did coursework and I did the following courses. It was constitutional interpretation, advanced criminal law, advanced law of evidence, and the last one was winding up insolvency and administration of estates.
I see that you started your legal career in 1988 as a prosecutor.
That's correct, Deputy Chief Justice.
And you became a magistrate a few years later in 1991.
That's correct, Chief Justice, Deputy Chief Justice.
You can just call me Justice Judge Kgoele.
Thank you.
Thank you. And during your stint as a magistrate, you also lectured at the Justice College?
Yes.
Lecturing to other magistrates?
Yes, that's correct, Justice Maya.
So you rose through the rank, became a senior magistrate, then a regional court magistrate.
That's correct, Justice Maya.
And you remained in the magistracy until 2008.
I didn't hear properly. Can you repeat, Justice Maya?
You remained in the magistracy until May 2008.
That's correct, Chief Justice Maya.
And in the following month, June 2008, you became an acting judge.
That's correct, Chief Deputy
Justice
Maya.
And the rest is history.
Yes.
How long have you acted at the Supreme Court of Appeal?
Supreme Court of Appeal?
Yes.
It's for a full year from the 1st of December 2020 up until November 2021, meaning full 4 terms. But I was called again this year from the first day of June up until the end of September, meaning that was an additional term. If I talk about the terms, it's 5 terms. But if it is in terms of the time, it's 1 year and some 4 months.
All right. And before you were called to act at the Supreme Court of Appeal, you had actually enjoyed some leadership stints in the High Court. You acted as a DJP.
That's correct. At Northwest High Court, where I was initially appointed, I also acted 2 terms at Mpumalanga High Court, where I later requested a transfer to.
Do you believe that those acting stints in the leadership position now prepared you for the Supreme Court of Appeal in any way?
I think so.
How so?
My reasons are, as a leader in a division, you are expected to, one, have a lot of experience, which experience enables you to be able to impart knowledge on your subordinate, mostly those that are junior. The second reason will be, as a senior or as a leader, when you do allocations of matters, you also allocate matters to yourselves. And those that are complicated, or probably, if I may use the term high profile, you will always allocate them to yourself. In that way, you manage to even hone your skills further.
How many judgments have you written at the Supreme Court of Appeal?
I have written plus minus 8 judgments. The 9th one, I wrote it during this term. It has already been delivered before the end of the term.
And I see that you've written on a wide variety of topics, legal topics, that is.
Indeed, Justice Maya.
How have you found your experience in that court overall? How would you describe it?
First thing, the workload is very high. Secondly, most of the matters, in fact, I can say almost all of them, they involve intricate legal issues. Thirdly, the atmosphere, in as far as the court situation is concerned, the circumstances there, I found it very warm. I was warmly received, despite the fact that most of the time, if not almost the entire time of last year, you, as the President of the Supreme Court of Appeal, you were not there. But I was warmly received by the Deputy President who was there, including all the seniors whom we usually refer to them as presiders. They warmly received me. They gave me a lot of guidance. They gave me a lot of support. And I managed, through the daunting task of those intricate cases through their help. As a result, I even managed to hand down judgment timeously. So the atmosphere was excellent for me.
The last part of your response was going to be my next question, because I wanted to find out if you struggled with the workload and keeping up with the pace.
I didn't. The delivery of my judgments, I don't want to waste time to go and look at them one by one, but they were all delivered timeously. There is no one in the Supreme Court of Appeal which was delivered late. I may sound to be repetitive, but a very good example is the one that I did this term. I think I have the date. It was heard on the 17th of August, if I'm not mistaken, and it was delivered on the 22nd of September. It's almost a month and some few days.
Yes.
It's almost a month and some few days.
That's a very good turnaround, Judge Kgoele. On to another tech now. You are a founding member of the South African chapter of the International Association of Women Judges.
That's correct.
And at some stage you were its president.
That is correct, Justice Maya.
And then at some stage you were the president of the Africa region of the mother body itself, the International Association of Women Judges.
That is correct, Justice Maya.
Can you just tell us very briefly what these associations do, what they seek to achieve?
It is an association of women judges. Its mother body is in Washington, as you had correctly said, in USA. Ours is a chapter. That is why we call it the South African chapter of the International Association of Women Judges. Its main objective is to advance the culture of human rights. It's the other, through training, the other objective is to advance women. And when I'm saying women, although the primary objective is women in the judiciary or in the legal fraternity, but also to advance women at large.
Have you finished?
Yes.
All right, thank you. Do you believe that they are achieving their goals?
The association, if I may ask Justice Maya, are you referring to the association?
Yes. Well, let's deal with the South African chapter.
Yes. It took us a long time because we started the association in 2004. But yes, it is. I'm saying that because one, we have programs that are advancing women rights that the association is embarking on. It's a lot of them. If I can talk about them, we won't finish. Two, in as far as the advancement of the women in the judiciary, yes. We have strived to encourage, push, mentor a lot of women judges and magistrates in the legal profession to advance to higher position. This
Yes.
resonate well with the issue of transformation of the judiciary. I will start with yourself, Justice Maya. You are a founder of this association. You have been in the association for quite a long time. We have strived from long time ago that we should advance women in the judiciary so that there can be 50-50 representation of women and men in the judiciary. We are not there, but at least today you are there sitting as the Deputy Chief Justice, which is a win for us. I don't know how to explain it, but that is a win for us. There are a lot of women judges that I can quote that had advanced to the Constitutional Court who are members in this association. There are a lot of women who advanced to the Supreme Court of Appeal, a number of them who belong to this association. There are a number of women who became regional court presidents, regional magistrates, senior magistrates who belong to this association. There are other women, I don't have a list, but I can just give you an example by, I think, a judge in Free State, if I'm not mistaken. It's just an example. Chesiwe, I think it's Sharon Chesiwe. She was not our member, but we recommended her to the position of a judge. I'm just singling her out, but there is a number of them who are from the legal professional bodies who are not women. By that, I'm trying to say that we not only advance women in the judiciary only, but women at large. Lastly, if I can just mention that we have developed a training arm of the association with a gracious donation by our current Chief Justice. We established a trust. This trust is the training arm of the association. With the trust, we aim to train or further advance women, and I'm repeating, not only women in the judiciary, but women at large, by doing a lot of training where we see the gaps. So we have started, and we are currently developing materials in as far as that is concerned. If everything goes well, our training will start in 2022. Thank you.
Thank you very much, Justice Kgoele. I can see that you are sufficiently relaxed now. I will hand you over to the rest of the commissioners. Colleagues, do you have questions to put to the candidate? Commissioner Dodovu, AP Betson, Moimane, Lucas, Nyambili, Tulisi, the Minister, that's everyone. JP Mlambo, you sure you don't have a question? Yeah, I have it. Thank you. You can go ahead, Commissioner.
Thank you very much, Deputy CJ. Good afternoon, Justice Kgoele.
Good afternoon, Commissioner.
Just two questions quickly. The Prescription Act, it is Act number 68 of 1969. And I can see that you have written two judgments at the SCA regarding this provision of the legislation. Now, my question is, don't you think the time is up that this act must be reviewed? Because there is always a contention about its interpretation. Don't you think that the time is right to review it? I hear bringing you to two cases that you handled, the Van Heerden case as well as the Akus case. In both instances, the contention is about the interpretation of the date of the commencement of the prescription. Don't you think that the time is up? Because one of the accusations or one of the attacks against you by the BLA is the fact that whilst you write good, solid, well-reasoned judgments, you tend to follow the law of precedence religiously without bringing in some innovation, or you lack intellectual backbone. Don't you think that the time is okay so that we will revisit that?
Thank you for that question, Commissioner Dodovu. Your question is a yes and a no. Yes, I believe that when the time is ripe, acts like the Prescription Act can be reviewed, but I'm emphasizing the fact that when the time is right. Because we do not just review the laws for the sake of reviewing them. Because you already touched on the comments that I've noted from the Black Lawyers Association, which comments are adverse to me, although they are recommending me. And although the tone of the language there, it's not so pleasant, but I respect their comment. I definitely respect their comment. But with due respect to the Black Lawyers Association, I think I dissected their comment for about 3 times. I dissected the criticism that was leveled against me there. I also dissected even the cases that I referred there. And if you can look at the very same case, if we can start with the Brumaire one. Chairperson, can you allow me a second to go there, because I want to refer to paragraph 17 thereof.
Yes. I think you're looking, oh, you'll know your record better than me.
Yes. I found it. In paragraph 17, I quoted a case that was done by the then Justice Moseneke, who later became a Deputy Chief Justice. And in paragraph 18, I quoted the case of Macmillan versus Bate. And I think the important part that I wanted to refer commissioners to is paragraph 19, which deals with Macmillan versus Bate. And in there, in short, I'm trying to say that the Macmillan versus Bate is on all fours with the present matter, or with the facts of the present matter that I was dealing with. But with that, I want to say this. It is important for one to know that we as judges do not just deviate from precedents just for the sake of deviating and wanting to develop the law. We do not just deviate for flimsy reasons. The important things are the facts of the case, the circumstances of the case that is before you, including the law applicable thereto, dictate or gives you a leeway of deviating or not deviating. Another important consideration which we as judges look at is, and which is important, is the manner in which the pleadings that are before you are phrased. They always guide you as to what the legal issue that is before you are. But in short, I want to say, there should be good grounds or special circumstances that must exist before one can even decide to deviate. Put it in another form. Deviation from a precedent which is a law in our country, must be warranted. It must also be rational. It must also be reasonable. So, in the matter that I have been criticized of, we took all that into consideration, that we don't just deviate for the sake of deviating. Or going back to what you asked me, Commissioner Dodov, you don't just review for the sake of reviewing. But in addition to the facts of the matter that I was dealing with, Brumer versus Brumer, the facts of the matter were such that there was no cry for looking at the section 39(2) of this Constitution that they quoted there. This is why even the senior counsels that appeared in that matter did not even urge us to go that route. Finally, the judgments of the Supreme Court of Appeal unlike in the high courts. In the high courts, there is many at times where you are sitting as a single judge, you write a judgment on your own. But in the Supreme Court of Appeal, we sit normally being 5 judges or justices, in most of the time, a panel of 5 members. So if it is a judgment like the judgment that I penned, yes, we may call it my judgment, but it is a judgment that had a collective ideas of 5 members. You can even see there that they all concurred. Now, if you can even look at that judgment, the panel thereof consisted of 3 most senior and
No,
seasoned
it's okay, it's okay.
judges.
Chair, I'm satisfied with the response that I received,
Thank you.
and I forgo my second question
Thank you, Commissioner.
because it had to do with the precedent system.
Yes.
Thank you. It's okay.
Thank you.
I'm
If you can
satisfied with
allow
the
me, Justice, Deputy President Petse was the presider in that matter. Justice Mba was also a senior member in that matter. A seasoned judge, Justice Zondi, was there. So, in short, there was no need at that particular time. The matter didn't call for that. And hence my answer initially was a yes and a no. So if the circumstances requires that or calls for that, yes, we will depart from precedent. Thank you.
May I just make an entry, Justice Kgoele, that you try and keep your answers as brief as you possibly can. I don't mean to interrupt your flow of thinking, but just try a little bit.
Thank you.
That way you won't sit there for a long time.
Thank you. I noted that, but I'm sorry to say this, that was the only adverse criticism against me.
Yes.
Amongst all the comments that I received, so I had to deal with it thoroughly.
All other comments having been positive.
All of them.
Thank you, Judge Kgoele. AP Beth, it's your turn.
Thank you, Deputy Chief Justice. Good afternoon, Judge Kgoele.
Good afternoon, Acting President of the Supreme Court of Appeal.
In the interest of time, I would not go into pleasantries. You are aware that when it comes to the interpretation of any legislation, a judicial officer must always keep the provisions of Section 39(2) of the Constitution at the forefront of their minds.
Indeed, AP,
You appeared before this commission on 21 April 2019 for the position of the Deputy Judge President for the Mpumalanga Division. And having had the benefit of reading the transcript, then you said that you did not even contemplate availing yourself for appointment to the Supreme Court of Appeal. What I want to find out from you, what factors weighed with you that made you believe that it is now time for you to raise your hand?
Thank you, Acting President. At that particular time, even the transcript will reveal I was just new at the SCA. I even indicated the fact that it was too early for me to say I am going for a position at the SCA, and that is why I availed myself to the position of a Deputy Chief Justice. But I think that I have gained enough experience from the time that I spent at the Supreme Court of Appeal, including the time that I spent at the Supreme Court of Appeal this year. In addition to that, I bring more than 3 decades of a wealth of experience as a judicial officer, sitting on the bench, presiding over civil, criminal matters, constitutional matters, family matters, a lot of them. And I am of the view that during my acting stint at the Supreme Court of Appeal, I demonstrated my capabilities and my competency in as far as adjudication or adjudicating matters on a high level at the Supreme Court of Appeal.
You have been a judge for about 13 years now.
Indeed, AP.
And with that length of service, I was hoping that in your documentation, I would find a list of judgments reported that you wrote as a judge in the High Court. Can you tell the Commission, perhaps from the top of your head, of how many reported judgments did you write in the High Court?
Can you just give me a sec so that I can just write and add a little bit? The ones that I could immediately find, I think, if I'm not mistaken, they are about 5 or 6, except those that I wrote, but I was with other members of the panel, not alone.
Have you got that list in your documentation?
I don't have a list, but I can, even in the list of the judgment that I've noted in my questionnaire, if we can go to my questionnaire. I know out of my head the Sheldon versus Lakey matter, whilst I'm still going there, is reported. It is in my questionnaire. And I also know about the Matitwani versus Regional Court President and another, 2018, in brackets 1, SACR 2 3209.
In any event, your answer was that over 13 years you wrote 5 judgments which were reported.
That is why I said subject to my counting being correct, and I said plus minus. But I didn't make a list, but I only quoted 2 in my questionnaire because the questionnaire was saying at paragraph 16.2, it was saying, perhaps I should start it at paragraph 16.9. It says, list the cases where you have a written judgment which you regard, not more than 10, which you regard as being the most significant. And I mentioned the list, and that list also includes those that were not reported. So the second paragraph says, the second question says, which of these cases, meaning the ones that you regard them as most important, has been reported? And then I quoted Sheldon Lakey, but it is only one there. I also included Brightwater, but Brightwater is from the Supreme Court of Appeal, because those are the ones that I said they are the most significant. So I didn't list all the others, like the Matitu one, it's only that I can remember it for now. I didn't include it at that particular time because these 2, I thought that they are the most significant to me.
Thank you. I see from the judgments which form part of your documentation that the majority of them are the judgments that you wrote at the SCA.
In that I attached. Indeed.
Yes.
Indeed, AP.
And you did mention earlier on that with the judgments that you wrote at the SCA, you received assistance from the other members with whom you sat.
Indeed, Acting President.
The feedback that I received from the presiders, all of them without exception in those cases, is that the final product is materially different from what you had produced as your first draft. And that much had to be done to your judgments to get them to a point where they could be delivered as judgments of the court.
Can I respond? I'm not sure whether
Please.
you are finished. It can be partially so, but the help and support that they gave me was in as far as, 1, advising me in terms of the style of the judge, what the writing style of the Supreme Court. The writing style of the Supreme Court, I think most of us know, is not the same as ours in the High Court. The High Court, sometimes we tend to elaborate a lot. Sometimes we tend even to include cases that are tried, is tried law. But we are learning, we are trying to improve on that, on the judgment writing style. But at the Supreme Court of Appeal, all the judgments that are, I mean, the cases that you refer to that are tried, that is tried law, I was advised you don't even need to mention them. So you will find that in my initial judgment, I elaborated on a particular case or authority which was tried. So in that manner, you'll find that the other cases that were tried, that I tried to probably to elaborate more, were taken out by the advice of the presider. We even know that even in the Constitutional Court, they don't write, their writing style is not exactly the same as the SCA. So, but the fact of the matter, DP, is the following. As far as the structure of the judgment is concerned, my judgment was always okay. As far as capturing the facts of the matter is concerned, I believe my judgments were okay. Even most importantly, the application of the law to the facts. The presider agreed with me and the approach to the judgment. Thank you.
In the normal course, you would receive suggestions from the other members of the bench, which would be incorporated into your judgment in track changes, in effect changing the judgment that you had produced. It was not a question of crossing T's or dotting I's and so forth. The suggestions were matters of substance, not stylistic.
It's a pity, AP, I was not aware of this adverse remarks from the presiders. It's a pity I was not made aware about it beforehand. I will have probably tried to prepare and bring those track changes, because I believe some are still in my computer, so that it can be, or the panel can be able to see whether they were matters of substance or corrections there and there. But in my own belief, I respect their views and what they informed you. They were not matter of substance. Thank you.
Don't you think perhaps it would help you if you were afforded more acting stints at the SCA to enable you to gain more experience, and hone your judgment writing skills?
No DP, no AP, sorry.
I'm sorry, I didn't get the answer.
My answer is no.
Thank you. That's where I will leave it, Deputy Chief Justice. Thank you.
Thank you.
Thank you, Deputy Chief Justice. Good morning, Justice Kgoele.
Good morning, Commissioner.
Just one question from my side, which was prompted by your response to the Deputy Chief Justice in your leadership role of the South African chapter of International Association of Women Judges. Do you think that patriarchy is an issue in the judiciary? And depending on your response, what is your view on the issue of gender parity being one of the criteria to be considered by this body in its process of filling vacancies to our judiciary? Thank you, Justice Kgoele. Thank you, Deputy Chief Justice.
Through you, Deputy Chief Justice, can I ask Commissioner to repeat the second one? I didn't get it in full.
Yes.
Do you think that the issue of gender parity
Yes.
as a criteria must be added to a number of criteria that we must consider when we deliberate on the filling of vacancies as an aspect of cushioning the effect of patriarchy in the judiciary? Thank you.
Thank you. The answer to the first question is that, yes, patriarchy, in my own view, I think it's still a issue that inhibits the fast transformation of the judiciary, because if you look at the judiciary, the leadership is still composed of a lot of men. But it is not only that. Remember, when we talk about transformation, we talk about the issue of even transforming not only the numbers, or we transform the mindset of our male counterparts, mindset of the leadership in the judiciary. So I think sometimes that is where maybe the problem is. There's still a lot that needs to be done in as far as transformation of the mindset is concerned. The JSC has said for quite a number of times in this. There is a very, very slow pace if you can look at the transformation, especially of the Concord bench. We rarely see the appointments of women there. 2, in the SCA, it was better. We have improved a lot. But I think if we can deal with the issue of the mindset in as far as this issue of patriarchy is concerned, we will be able to win. Your second question about the criteria of gender parity. Yes, I fully support the fact that It should be one of the criteria. But it should not just be a criteria that women should be appointed. I don't know how it can be crafted, because we really do not want parity in the sense of numbers being 50 to 50, men 50 to 50, when the women that are appointed there don't make a difference. One, they must be competent. We don't just want to be appointed as women because we are women. No, we don't want that. We don't want to raise a female card and say, because I'm a woman, I must be appointed. No, we don't want that. And we want women that sit on the bench that can be able to change the lives of our citizens out there. Because we judges, we speak through judgments, through our judgments. We must do that. We don't just have to be on the bench there just to make numbers to be 50-50. No, but I fully support that it should be there. It should be taken into consideration how the JSC crafts it. I cannot spell it out. I'm sorry. Thank you.
Thank you, Justice Kgoele. Thank you, Deputy Chief Justice.
Yeah, it was your turn anyway.
Thank you very much. And TCJ, you will understand why my voice is good. Thank you very much. I just want to once again congratulate you and also agree with Justice Kgoele that it is a victory for us as women to have you in the seat where you are. And I'm saying that because my question, good morning, Judge Kgoele.
Good afternoon,
Is it
Commissioner
afternoon
Lucas.
already? It's fine. I slept late last night, so to me, I'm still at night. I'm still in the morning. Yes, we met in Kimberley the first time when you came there with the international chapter and so on.
During
So-
the conference.
See, during the conference. So when I saw you this morning, I was just like, where did I see this person now the last time? And I remember that we appointed you for DJP of Mpumalanga. But in fact, my question was about the issue of, I was looking through the issue of demographics, and I want to agree with you that you have, at least there was a lot of progress under Justice Maya at the Supreme Court of Appeal in terms of appointing capable women in their positions. But there was something that I wanted you to address, is that in your own view, how do we really, what do you propose we do to address the concern that we have, the very same issues that you raised of capacity and capability of the women that we appoint? Because we are seeing many women that is being appointed, but there is still that prejudice that we just appointing women, they are not the best that we are appointing. I just want to listen to your own view in terms of that, and what do you propose we do to address that attitude so that we can see more women being empowered, let me put it like that. And then I want to summarize as the next one is, and then according to yourself, what would you say in your career is as a jurist, was the moment that you feel you are really now accomplished? It is like what people will say, that wow moment as a jurist. That will be my questions. Thank you.
If I understand your question well, Commissioner, but you'll pardon if I didn't comprehend it properly, but I think you are talking about women or judicial officers that are already appointed on the bench.
I would want you to be a little bit general, but
Okay.
not too general, so that it won't be, take a long time to respond.
Training is very important. Our women who are already appointed and who are also not important, it's very, very important. And probably I'll go back to the association. That is why we thought that we must have a serious training arm in the association. We did that with the full acknowledgement of the fact that there are a lot of training that is occurring in the judiciary. We have the what we call SAJ, South African Judicial Institute Institute of Education, which is training the judiciary at large. And I come from a viewpoint that training can never be saturated. And you cannot, if you are a person, you cannot stop being trained. I know my sister association like Saola, their members are here. They also do training. But in short, there's a lot of training that is occurring, but to address the issue in the judiciary, that is why we said we must really, really embark on doing our own training where we upskill women. And it's a pity I don't have the objectives of our training in as far as the association is concerned. But we envisage even training all the women. One, whether you aspire to become or to go to a higher level or not, we have developed that kind of training. Whether you don't want to go to a higher level, we have embarked on that training. For example, the social context training, which we find it as key, very key to judicial officers. We still need to do social context training. Unfortunately, one of the product of the first social context training that that was embarked on when I was still at Justice College, when I was training magistrate, with the funding from the Canadian. We called it an intensive social context training. I was one of them. And through that, we managed to train a lot of magistrates at that particular time, so that we can infuse the human rights culture, the civil rights culture into the law, into the judgments that we deal with. So it is very, very important. But I was trying to say, even if you don't want to aspire to a higher position, that kind of training is needed so that we can have good jurists. We have a specific program that address those that wants to aspire to the leadership positions. We call it a leadership and management course. There is a lot that we are dealing in as far as training is concerned. So I will say training is important, Commissioner Lucas. That's how we can empower women. Now, the second question relates to what I accomplished as a wow. It's a difficult question for me, but I'm going to try. There's a lot, in fact. That's why I'm saying it's a difficult comp. My accomplishment as a judicial officer, the first one is having served as a springboard, having encouraged, having supported a lot of women, even if I was a junior to them, to advance to higher positions. That was a wow for me. 2, I did training. So training is a passion for me because I imparted a knowledge to so many in the department, even including interpreters and the clerks of court, everybody there. The third one, the last one, is transforming. I usually talk about this because it's my passion. Transformation of the judiciary, which I did when I was sent to Appington. I did a lot there in transforming the office. That was a wow to me. When I left that office, I was more than satisfied. Thank you.
Are you done, Commissioner Lucas?
No, actually, I was shocked that you mentioned Uppington. It might sound as if I am biased because I'm from Uppington. I just
You may
wanted-
ask your follow-up question.
I just wanted one thing. You speak that there is a lot of training and so on, and you are empowering women. How are you also addressing the issue of men? Are the men that is involved in the training sessions when it is like for just actually to change the mindset? How are you also contributing to that part? And then, thank you, DCJ.
Thank you, Commissioner. Indeed, we are. For example, when I was at Justice College, we were training, it was not specifically meant for women. But probably I concentrated on training on women because of the fact that we still need a lot of women in as far as gender parity is concerned. But the long and short answer to what you are asking me is that even the training material that we are dealing with, we will even try and include the members of our association in the training. In our association is not only composed or comprised of women. We have men who are members of our association. So the training is specifically aimed for members of our association, which are both men and women. But the social context training, which is important, is across the board. Thank you.
Thank you very much, DCJ. Thank
Commissioner
you.
Nyambi?
Thank you, DCJ. Afternoon, Judge Kgoele.
Good afternoon, Commissioner.
We have served as a judicial officer for more than 31 years,
Indeed,
18 and 7 months as a magistrate and 13 years as a judge. And the Supreme Court of Appeal is a very important division in our country. As somebody that has acted for more than a year at the SCA, if you can single out 2 critical challenges that you think you are going to assist to address, if you can be given an opportunity to be a permanent judge at the SCA.
Firstly, as you indicated, I've got 31 years experience sitting on the bench. I have vast experience in civil, criminal matters, administrative, constitutional matters, social context, which in my view will be able to bring a change in as far as the decision making is concerned in the Supreme Court of Appeal, which resonate with the thinking and reasoning post 1994. Two, that if you have already said I have a lot of experience as a magistrate. As a magistrate, you also deal with a lot of issues around family law, issues especially about criminal law, those issues, in my own view, deals with issues that affect people on the lower ground. If you can even look at some of my judgment, you will realize that in all my judgment, even including the Supreme Court one, not sure if you can just give me 1 second, I can quote one. I don't think I included it in the.
Judge Kgoele, maybe to assist, it's not only about your experience. I'm interested in challenges facing SCA.
Okay, thank you. Thank you for the correction. Let me revise. One that I can immediately think of is gender parity, because then if more women are appointed in the SCA, it will bring hope to our citizens. Yeah, I can think about that in as far as challenges are concerned.
My last one. Any other thing that you might consider your weakness that needs some attention? What is your weakness?
I cannot think of any weakness that can need an attention for now. I know a weakness can be a weak point, but in most of the time, I think my weaknesses gives me a strong point because I am a very calm. I can adapt to any situation. at any time, so I don't think there's anyone that I can think of now that need attention.
Thank you, Judge Kgoele. Thank you, DCJ.
Commissioner Marumafai?
Thank you very much, Acting Deputy Chief Justice. Good afternoon, Judge Kgoele.
Good afternoon, Commissioner.
I want to ask two questions, but before I do, just one for clarity. Did I understand you correctly that in light with the criticism that BLA leveled against you, you believe that it's unfair because in the matters that they referred to, Section 39(2) was not applicable? Did I understand you correctly?
No, I don't think you understood me correctly. I am not saying their criticism is unfair, not at all. Because that is how they interpreted or understood the judgment that I wrote.
Okay, let me try to assist you perhaps. The question I'm asking, that let's leave the BLA aside.
Okay.
In the two judgments, Truther and Bruma, Bruma dealt with the anti-mutual contract, and we know how those contracts generally affect women in society. That was Bruma. Truther dealt with personal injury sustained by a medical procedure, and we understand the constitutional issues that might arise out of that from a health perspective. So I just want to understand, are you saying that in those two cases, Section 39(2) did not find application? That's what I'm trying to understand. Let's forget about the PLA.
In true time, maybe, but I'm saying in Brume because they were criticizing my judgment. In Brume, I'm trying to say the facts of the matter that was presented before me didn't cry for that.
I'm not sure if you were able to pick up, but Acting President tried to assist in that regard, saying Section 39(2) actually finds application all the time. I'm not sure we were able to pick that up because of what it deals with. And the thing is, this then lead me to the point that I want to pick up with you. And you said it in one of the comments that you made, that in your judicial career, you want to change lives of our people out there. And I think when one looks at the BLA's comment, it's not a criticism per se. It's actually a call for consciousness to say, let's look at the Prescription Act. If it was as clear as we think it is, that after 3 years, you don't have a right to come to court and all those things your claim has prescribed, we wouldn't have as much litigation as we are having. And what they are saying is, continuously, various courts, including the Supreme Court of Appeal, I'll go further and say even the Constitutional Court, they bring judgments that really causes confusion in the application of this particular legislation. And they raise a particular provision on it, Section 12, subsection 3. And they are saying that particular provision, it requires some judicial innovation to assist us while we are waiting for Parliament to get its house in order. So what they are saying is, you seem not to be doing that, but religiously follow. Perhaps maybe the intellectual backbone comment might have been too strong. I don't subscribe to that. But what I'm saying is, that particular legislation, when you look at it, and the different judgments that have came forth, the comment is you religiously follow precedent, even in instances where you can deviate, given the court where you are, the Supreme Court of Appeal. That is the comment. I'm not sure it's a criticism. It is just an awareness to say, as not only you, but all the judges, like, let's look at this thing. I'm not sure, do you have a comment on that?
I have, but the way it was phrased, it was specifically referred to me. the way it was written there.
Indeed.
Yes.
But I'm saying functionally.
But that is why I'm saying, I'm not even saying it is unfair. It is a fair comment. And you will remember that I answered that question in relation to the question that was asked by, I think it's Commissioner Dodovu. And his initial question was, is there no need for a review of the Prescription Act? And my answer to that was yes and no. And that is why I said my answer was, and I fully agree with you, that we should be aware of this. We should include the Section 39(2) of the Bill of Rights. We must always think about it when we interpret legislation. I'm fully aware of that. But to say yes, in particular or in reference to this matter, I'm saying the facts of the matter at that particular time didn't dictate that. But I fully agree that yes, it needs to, it can be. And that's why I gave an answer of yes and no.
Can I ask a last one?
Yes, and let's just have a crisp question,
Yes.
please.
In relation to, I mean, currently what we are seeing in our courts, we look at the people who are litigating in the courts, mostly are white male, right? And we don't see women in particular leading cases in most of the cases, especially in the Constitutional Court, from all the races. What has your role been, not from a judicial point of view, but from a practice point of view? Because we draw judges from practitioners, right? And it is that practice that will enable them to become better judges, at least that's a belief. What has been your role in ensuring that young female practitioners are able to more and more appear in perhaps maybe the Northwest, the local, the division in the Northwest and the division in Mpumalanga? Thank you very much.
Are able, if I want to get more clarification, are you saying are able to appear
Yes,
in the courts?
to run matters in the courts. I know that you are not the one who's briefing them, but I'm just saying from a transformative point of view.
Yeah. As far as practitioners are concerned, the role that I can only talk about is that when I was still at Mpumalanga, when I was an acting deputy judge president, we held a sort of like a seminar, but there's a terminology that we use, wherein we were not necessarily training, but talking about the law, empowering them in as far as the law is concerned, at Middleburg. Here's the term, sort of trial advocacy. Yes, we did that when I was in Middleburg. But maybe let me just add a little bit, because in as far as women who are not even yet attorneys and advocates, I think almost the whole country, we are having a mentoring program that flourished during my presidency, where we mentor law students in all the universities. Thank you.
Thank you.
Commissioner Noches?
Thank you, Mr. Chair. Good afternoon, Justice.
Good afternoon, Commissioner Noches.
Yeah, look, would you agree with me that for judicial appointment, there is different standard for the High Court and the higher courts, like the Supreme Court of Appeal and the Constitutional Court, in that for your High Court at least, potentially you must demonstrate. But for the SCA, you must definitely demonstrate that you are an all-rounder, you are ready, you are a jurist, you are a judge. Do you agree with me on that proposition?
I fully agree.
In order for this body to conclude that, for instance, in your case, that you are indeed an all-rounded judicial officer who is ready for appointment in the SCA, that must be determined with reference to your judgments.
Yes.
In this case, you have only attached for us the judgments of the SCA and one judgment of the full bench from your division. And we just don't have judgments where you sit by yourself, except for those two judgments that you have referred to. Or perhaps you suggest that there are 5 reported judgments that you have. My question based on this, taking into account your debate with the acting president of the SCA and what we have, would you say we would be in a position to determine whether, as a person, you are ready for the SCA in the sense of you being a complete judge who has established a jurisprudence of her own?
Thank you. I just want to go to the summary of the judgments that I attached. The first one that I attached, I'm going to start there. The Leone versus Leakey versus the state. Leone Leakey versus the state. It deals with it's criminal matter. It deals with rape. So in that sphere, I'm fine. I just attach it, for example. The Sajwa royal family deals with administrative law. Now, the bride water props also deals with administrative law, including the principles of legality, including the issue regarding Section 1721, which deals with the just and equitable remedy. It touches on the Constitution. I'm going to skip Pretoria, DPP Pretoria versus Zulu, because it's a criminal matter. I have already dealt with that one. Now, the Brume one that we have been talking about, it's civil law, which deals with prescription. I have others, I think 1 or 2 others. The Sipla versus Miriam.
Sorry, CJ, acting CJ, if I can stop you. I've talked to judgment where you are writing by yourself. You are by yourself. These are the judgment, I agree. These are your full bench and the judgment of the SCA where you are a collective. I'm saying your own judgment. Can you refer me to that?
I didn't attach them, but I think our report judgments and most of my judgments are reported in SAFLI. I didn't attach them. They are reported in SAFLI. During my last interview, when I checked, I have especially in the High Court, more than 200 judgments that I penned. And they vary from various sections of the law. So I didn't attach them. I attached a few because I cannot attach all of them here. And to be honest, they are not all in my head. Yes, for now. So that is why I was trying to demonstrate about the ones that are before me. And if you do not want me to go to the Supreme Court of Appeal judgments that I dealt with to show that I dealt with various aspects of the law there, which I gained experience on, then I will end here.
With your leave, CJ, this is my last question. The difficulty I have with the judgments that you referred to of the SCA, we have already heard the remarks by the presiding officers in those cases. That's my difficult first, that the presiding officers had some remarks. You needed to hone your skin in that regard. Now we wanted your own judgments where you have written, and then you don't have. We have to go to SAFLI. My last question, which is just what I want to establish from you, is bearing in mind that the Supreme Court of Appeal, save with the extension of the jurisdiction of the Constitutional Court in respect of constitutional issues and public interest, but the SCA on its own is a highest court in terms of those matters that it is, matters that concerns to law and all that. And the judges that are in that court, in my view, must be ready, not just a potential, because they must give directions to courts in the to judges in the High Court, and must develop the law in the Republic. All what I would like to hear from you, what is your judicial philosophy? And where that becomes apparent in terms of your judgments? That's my last question.
My judicial philosophy is based on the fact that we are having a constitution, which is the supreme law of our country. But I come from a viewpoint that the constitution is not like a book, or where if you interpret it, you must just interpret it literally. I come from a viewpoint that in as much as it is the supreme law of our country, when we interpret it, we must be open. Our constitution must be a living chapter, wherein our interpretation of the existing law must have the characteristics that are enshrined in the Bill of Rights. That's my philosophy. I can quote an example of a matter in the High Court, Akas versus Akas. In the Akas matter, if you look at that judgment, there is a consenting judgment to the main one, wherein we felt so much that I concurred it with Justice Mutsumi, the concurring judgment, but we felt so much in that judgment that it doesn't bring the very same element that I'm talking about of bringing up the issue around civil rights, human rights, because that judgment was, again, unfortunately, dealing with prescription, but that it was prescription of the Maintenance Act. So we felt very much that we should bring about the fact that in interpreting the Maintenance Act and the Prescription Act, we cannot close our eyes to the realities that the women in this country suffer. We are not saying men are not affected by the Maintenance Act, they are. But women are more affected by the Maintenance Act, far more than men. So if you can look at that judgment, we are trying to bring across the fact that we should interpret it so that it can be able to protect or bring across this perpetuated treatment of women in as far as maintenance is concerned, which affects them mostly. And that is why we wanted to bring that up.
I think you have answered my question.
Okay.
Thank you very much. Thank you.
I thought you'd ask your last question. Oh, I thought you were asking another one. So sorry, Commissioner Nekis. Thank you. Commissioner Shabangumdao.
Thank you, TCJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Are you good?
I'm trying to be. With the harsh questions, I'm trying to be.
Yeah, I think I had two questions for you, and they have been covered by the other commissioners. But I just want to thank you for your contribution in the transformation of the judiciary, and also your actively involvement in mentoring those who are coming after you. Commissioner Marumo Agai ask you a question as to what extent are you contributing in assisting those women lawyers to be able to appear in courts? And you understated whatever that you are doing for women lawyers. Saula in Mpumalanga, in their supporting letter, they mention that you go out of your way to mentor young women legal practitioners. Can you maybe want to share with the commissioners as to what is it that you are doing thus far? Because I think it will cover also the question that was asked by my brother next to me. Yeah. Thank you.
Sometimes I do personal-to-personal mentoring of the legal practitioners. Especially, I will quote in Mpumalanga. I mentor them and advise them. One of the good days they requested me to give them an advice as to when they appear before me, what do I see them lacking on when they appear before me? I should sort of spell out and advise them how to present their case better. I did that to a few, and also, I think you know, Commissioner, you are the chairperson of Saola. I normally come to your conferences, and we normally address issues that relates to legal practitioner or women in the legal fraternity. And some, when they are even given an acting appointment, I mentor them on a person-to-person basis in as far as writing judgment, approaching the judgments are concerned. I'm not sure you will feel comfortable if I can mention you as one of them, but you are one of them. I mentored you when you were acting in the Mpumalanga High Court. I also mentored you when you became a president. You said to me, please assist me, mentor me in as far as leading this association is concerned. And I did it up until now. Thank you.
Thank you, Judge Kgoele. I hope you will continue mentoring others who are coming after us. Thank you.
Commissioner Matolo-Dlebo.
Thank you, ACJ. Good afternoon, Judge Kgoele.
Good afternoon, Commissioner.
Mine is a very simple one. You know, when you appeared before us the last time,
Yes.
there was an issue about the judgment that you hadn't finished. Have you done so?
Yes.
Have you done so?
Pardon?
Have you concluded that judgment?
The criminal
Yes,
matter,
yes.
the part head.
Yeah.
Indeed.
Okay, thank you.
If okay.
Because I wanted
No.
you to close that part.
That chapter. I
Yeah.
did, and I did it during, not even during term. I used my time around January to finish it. And remember, it was having 32 counts. Yes, thank you so much.
Okay, follow-up question. You know, you have been talking about training, but I don't want us to come out here with a perception that only women need to be trained. You know, men also need to be trained. But in your point of view, I know that you do a lot of mentoring young female attorneys. I've seen you a lot, but there must be something lacking that we need to add. What do you think can be added to make sure that they are more comfortable in the judgment writing, and especially your organization as the South African chapter of women judges, can they assist in that regard?
In judgment writing.
Yeah.
Thank you, Commissioner. In the training that I'm saying we are developing, we do have judgment writing. In the training that we are developing, we have already developed a training template in as far as that is concerned. We have already been populated that template. As I've indicated, we are only just waiting for approval. Not approval, the training itself, which is going to start in 2022. we are definitely, it is one of the topics or the programs that we envisage in the curriculum development that we developed in as far as our training is concerned. We are going to do that. That's judgment writing. Yes.
Thank you, Judge. I just hope that you will include men in that judgment writing.
No, we are going to do that. Thank you. And I said that it's a pity I don't have the purpose of, or the objective and purpose of our training curriculum before me here. I will read it. It says, all members of our judiciary, which are men and women. Yes, we'll do that.
Thank you, CJ.
Minister?
Yeah, thank you very much, DCJ, and good afternoon. Mine is straightforward and one question. Do you believe, in the context of one of your judgments, the Sheldon Lackey, if you don't remember the one that involved a female educator, do you believe in that a sentence does play a role in deterring other will-be offenders?
Can I ask, are you done, Minister?
Yeah, on the first part.
I heard you, let me get a correction. I heard you saying, do you believe a sentence? I'm not sure, because we have different sentencing option. Which sentence? Is it a sentence on its own, if I want clarification? Or you wanted to say custodial sentence? Or?
Yeah, custodial sentence, or any sentence, whatever sentence, do you believe that it does play a role to deter those who may be or will be offenders in the future?
Sometimes it does. But if I talk about sentence as in general, not a sentence as custodial or a correctional supervision sentence or a suspended sentence. But if I talk about a sentence in general, sometimes it does, it deter, but sometimes it does not. I believe that sometimes the issue of restorative justice helps in as far as offenders are concerned. I also believe that at the moment it's only occurring in as far as cases that involves young children are concerned. The issue of diversion. If we divert matters long before it comes before the court and long before it even deals with sentence, or we send people, or we sentence people, it can help a lot. Thank you, Minister. They said I shouldn't talk too much. I'm going to stop there.
No, you're brave this time around. Yeah, it's almost the same question, but lastly is, what do you think should be done by the OCJ or the Justice Department or the entire cluster to educate society about the sentences or whatever, in whatever form that come out of our court? I'm asking this in the context of our country, the high prevalence of crime. And on a day-to-day basis, someone is being sentenced in this country, whether it's custodial, whether it's a harsh sentence in Musina, in the Eastern Cape, anywhere. But we still see the crime rate going up daily, despite us expecting and hoping that what goes through the system will be a deterrent. And I know that there are other factors, but what do you think could be done to educate society more about what is happening in our courts in regards to these processes and sentences, except just us relying on the media, if we are lucky to report?
I think the usual awareness campaigns that we can embark on, a serious awareness campaign that we can embark on in educating our communities. It will help. One of the other methods that probably we can increase on, Minister, the Gender Directorate, they are spearheading the family dialogues. We used to partner with them in as far as issues of family dialogues are concerned, and that is where we are able to bring the whole community at issues like this. I'm talking about a family dialogue, but it cannot only be a family dialogue. We can name a sentencing dialogue or whatever that we can deal with. But I'm trying to give that as an example. In my own view, we'll be able to reach a lot of the communities out there.
Yeah, thank you.
Commissioner Mokonis?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge Kgoele.
Good afternoon, Commissioner. I can't see your name, but I will call you Commissioner.
Okay. No, I have two quick questions. One, what would you say to people who believe that the law is the weapon of those who own the economy to consolidate their power in society? Do you have some sympathy with that view?
Can you repeat, Commissioner?
Okay, what would you say to people who believe that law is the weapon of those who own the economy to consolidate their power in society? Do you have some sympathy with that view?
Law is a weapon of? I can't hear properly.
Okay, law is the weapon of those who own the economy to consolidate their power in society. Do you have some sympathy with that view?
In a way, because in as much as the law is supposed to be used to address and protect the most vulnerable in the society, especially in South Africa. But you will find like one, access to representation in as far as litigation in court. Most of the time it is expensive. So our vulnerable people down there, in as much as we have good laws, in as much as we have good policies that are supposed to protect them, they are not even able to get advantage of that. Now, the law must cut across. whether you are rich or poor. It must protect everybody. And our constitution is like that. But why, if you look at the law, especially some of those that are still not reviewed, and that is why we as judges sometimes are called for to be activists, judicial activists, to even try and interpret the old laws. Remember, our laws are still based on Roman Dutch law. Some are not even relevant to the current situation. I will just quote the law of contract. It dates back from the long old days. But you will find that there are established principles, and if you can look at them, they mostly protect. Did you say white? Not white, but the rich community, if I want to quote you properly. But yes, I'm saying it does not necessarily protect them, but the cases that appear before us in as far as the law of contract is concerned, if you can look at it, they mostly affect those that are rich. Whereas if you look at criminal law, it affects our vulnerable people. And that is where the issue of legal representativity comes in. But unfortunately, they won't be able, they in most of the time don't afford to pay a lot of money in as far as getting the best legal practitioners. Thank you.
Thank you very much. The last question. Do you think that there is a room for our legal system to be developed, to be more inquisitorial than adversarial? If yes, how? If no, why?
Yes, it needs to be more developed to the inquisitorial one, because our law is adversarial. Although it will need a lot of efforts to change that, but I think in the meantime, it needs us, judicial officers, judges and magistrates, to not just be like a referee or umpires in court. We must be active. We must, in a way, be involved. Because with inquisitorial, the judges there are involved in the matter. I'm not saying involved in a sense of becoming investigating officers. I'm not trying to be there. But we don't want to be seen to be just umpires in the court who says, yes, you are right, you are wrong. You must be involved in the manner, but remember, there is a thin line. Your involvement should not be seen to be descending into the arena. I think we need to do more in the meantime before we can even do a reform of our judicial system. Thank you.
Thank you, TCJ. Thank you, Judge Kgoele.
Thank you, Commissioner. Commissioner, madam, it's your turn.
Thank you very much, DCJ. Judge, I see you trained magistrates in Namibia.
Indeed, I think it's justice. No, Commissioner Maleshane, my friend, even if I don't see your name, I know.
Yes. So, given these borders and the unity of the African continent, do you think is there any role the legal fraternity can play in uniting this continent, since you are able to go and train the magistrate in another country called Namibia? Indeed, I believe so. Yes. And then the other issue is the issue of being a member of the Academic Advisory Board at Free State, the LLB one.
Yes.
Do you think there is a need for decolonizing education so that that which you teach our children reflect who we are and make them to identify with the continent? As a member of the Academic Advisory Board, are you playing any role to ensure that the education, especially law, that we get to teach at school is decolonized and is reflective of who we are? Thank you, DCJ.
I fully agree with you on that one. The only thing is that I think if you can see in my CV, I've not been long or roped in that advisory council. But yes, remember the laws and the laws that we teach must respond to the realities that we face as a society. Now, roping people like ourselves, like judges, firstly. As a judge, I'm not totally divorced to the realities that are appearing in life. West, I come from a very, very rural place called Kgoele, if you know where Kgoele is. 2, as I sat on the bench for quite a lot of time, we tried to bring, even during our training when we were dealing with training in Justice College, we tried to bring experiences that we experience when we are sitting in this court, in the lower court, to the fore and to our judgment. But now we are saying, I think roping people like ourselves is trying to bring the practical aspects of what we are dealing with in courts into their curriculum, into what they are being taught about. Because if you can look at what is happening mostly in the university, we are mostly taught theoretical things, the law, but in a theoretical sense. Once you get your LLB degree, or once you even get your whatever degree you have and you go and face now the real world of working, from that position to work, whether as a practitioner, legal practitioner, or as a magistrate or as a prosecutor, but I talk from my experience because I started as a prosecutor. It's difficult, it's not easy. To take that theory into practice, it's not easy. So we try to bring that element of advising the curriculum about perhaps things that they can include so that the student might even experience the practical aspect of the realities that is occurring in our societies, so that our curriculum are in line with it. Thank you.
Are there any questions from our colleagues on the virtual platform? Commissioner Banada is still there? Commissioner Bredenbach? Ah, there you are.
Thank you.
Do you have any questions?
I have a question.
You're on mute. Please unmute yourself.
I'm speaking. Can you hear me, Chief Justice? Deputy Chief Justice? Can you hear me?
Yes, we can.
Thank you very much. Good afternoon, Judge Kgoele. Last year, the SCA in a unanimous decision overturned one of your judgments. It was about spoliation. It's one that you list. It's the matter Bischoff versus Welberplan Boerdery. So it's about the law of property and the basic aspect of spoliation. The two requirements: one, there must be peaceful, undisturbed spoliation, possession at least. Sorry, and secondly, that it had to be disturbed. In the matter, you found you held that there was that a letter written for someone not to trespass on the property equated to spoliation. Is there a specific legal precedent that you look at to rely on for that that finding, or what persuaded you to make such a finding, which of course was overturned later by the SCA?
Unfortunately, I won't be able to pinpoint the law that, or the specific authority that influenced me, because if you can look at that case, I think I mentioned in one of the decisions that were overturned, it's a case that I dealt with a long time ago. I can't remember that, except to say that in that matter, there was sort of no precedence in as far as spoliation, whereby a claim of spoliation was done through a letter of demand. The issue the main issue there was a letter of demand. But I can't pinpoint, I don't have it here before me, and I can't pinpoint what authorities led me to that decision. I wanted to just check the date of that judgment, question 3. It's a very old judgment that I dealt with, I think, when I was even new at it's Bishop. Yeah, unfortunately, I don't have, but it's a very old one. Although it came very, very late to the Supreme Court of Appeal, 2021. Am I allowed to check the citation on my phone? Because I think it should be there on Safely to check when did I deliver it. It's some time, long time ago.
Do we need her to check the citation online, Commissioner Bernard? Is it necessary?
I can't remember. I can't remember everything what I dealt with, except that I can remember, as you are talking now, that it dealt with a letter of demand as a spoliation.
It's just that's exactly the point. I don't think it's any appreciated. I think the question is just how did you arrive? You know, what brought you around to find that a letter written about somebody possessing land actually amounted to them being disturbed in their peaceful possession of that land. Just that extension of the law that is somewhat strange. Perhaps I would like to clarify.
I can't hear properly, but if I heard you, you'll correct me. I can remember that little part of the facts, but remember there will be council who are making submissions based on yes, authorities perhaps, that will have probably persuaded me, but I can't remember them now. It's an old case.
All right. Thank you, DCJ. There's nothing further from me.
Any further questions from the virtual platform? I don't see a hand. All right. Judge Kgoele, thank you so much for your time. It looks like we have reached the end of your interview. You are excused.
Thank you very much, Justice Maya.